We are live in YouTube, so thanks for the audience from YouTube and from the Zoom meeting room. Professor Claire, Professor Daniel, it's a pleasure to receive you today to compose this panel, Business and Human Rights in Europe, an initiative of the Germany Chair International Conference, supported by the Erasmus Plus funds of the European Union and hosted by the FECAP Business School. Briefly presenting our guests today, Professor Claire Bright, who's a PhD in international law from the European University Institute in Florence. She's an assistant professor in private law, as well as the founder and director of Nova Center on Business and Human Rights and Environment at the Nova Law School in Lisbon. She's also Associate Research Fellow at the British Institute of International and Comparative Law. So thank you so much, Professor Claire. Professor Daniel Elgenstein, who's a PhD from the European University Institute in Florence. He's an Associate Professor at Tilburg Law School, Public Law and Governance, the Netherlands. With his work on business and human rights, Daniel has contributed to national and international academic and political forums, including the United Nations, the European Union, and several federal governments. So thank you so much, Professor Daniel. And we will start today with Professor Claire. So Claire, the floor is yours. Thank you so much.
Thank you so much, Rafael. Hello, everyone. Thank you very much to the organizers for the invitation to be here today. I'm going to share my PowerPoint presentation with you. I'm hoping you're able to see it okay. Good. Okay. Right, so my own presentation is going to be focusing on the development that are occurring in Europe on business and human rights. And I thought I would start by sharing with you some of the key findings of a study that I co-authored for the European Commission on due diligence through the supply chains, which form the basis of the legal developments that are currently going on. And so it's helpful to sort of understand the background. In this study, so that study is made up 4 components. We did market practice, so we surveyed over 630 respondents, both companies, but also other stakeholders from NGOs, trade unions, governments, academia, etc., legal practitioner, in order to try and understand what are the state of current corporate practices in Europe. We also undertook 50 interviews and informal calls, and also 10 company case studies. Then in the second part, we did a regulatory review, looking at the regulatory landscape in Europe and beyond, and that including 12 country reports, and my colleague here, Daniel, authored one of them, one of those reports. And then we looked on the issues, what were the problem analysis at the European level, and proposed some regulatory options and what could be done going forward. And the last part of the study was an economic assessment with analysis of the cost and benefits of the different regulatory options. So I would just like to come back on some of the key findings to sort of set the scene really of what is going on in Europe. First of all, one of the key findings of the study is the limited uptake of the human rights and environmental due diligence expectations by companies. Only 1/3 of business respondents indicated in their survey that their companies undertake human rights and environmental due diligence. And for the majority of those, this exercise was limited to first-tier suppliers, which is problematic because quite often human rights issues are to be found further down the chain and further down the supply chain, more specifically. These results, we can also find this sort of low uptake by companies in various studies that have been carried out at the national level as well. So if we look, for instance, in Germany, the result of the 2020 monitoring process revealed that only 13 to 17% of companies with over 500 employees adequately met their due diligence obligations. In Portugal, where I'm based, the first national inquiry on responsible business conduct found that less than 1 in 5 companies have due diligence processes in place. So you can see that sort of general trend here in Europe. When we look at the incentives, in our study, we asked companies the companies that were undertaking due diligence, what were the main incentives for them to do so? And the 3 top incentives were the reputational risk, the requirement from investors, but also the requirement from consumers asking for a high standard. So this is what currently is pushing those companies who are doing due diligence to exercise human rights due diligence. So against this backdrop of that limited uptake of due diligence expectations by companies in Europe, what we are seeing, and obviously this being also a symptom of the limitations or manifestation rather of the limitations of the soft law approaches and the voluntary and self-regulation approaches that have been so far predominant, what we are seeing in recent years in relation to regulatory landscape is a hardening of the soft law. So here on that graph, you can see the increase in the regulation that is currently happening in Europe, with a growing number of jurisdictions that are adopting or considering legislative measures to encourage or to require companies to exercise human rights due diligence. And when we look in detail at this type of regulations in Europe, we can find 2 types in particular, 2 main types. The first type are mandatory reporting regulations. So these are regulations that aim to encourage companies to exercise human rights due diligence through reporting requirements. An example of that is the UK Modern Slavery Act that was enacted in 2015 in the sort of following up on the footsteps of the California Transparency in the Supply Chains Act, and which imposes companies, UK companies, but also companies doing business in the UK, reporting obligations on the steps that they are taking to ensure that slavery and human trafficking is not taking place in their activities or in any of their supply chains. Now, this type of reporting regulation we can also find outside of Europe. I've mentioned the California Act, but also in 2018 in Australia, there was a similar, the Australian Modern Slavery Act that was adopted. However, one of the main limitations of these approaches is their lack of teeth. In particular, the enforcement mechanisms on which they rely and the sort of presumption on which they are sort of formed, which is that the so-called courts of public opinion, which is basically the consumer, the investor, and the NGOs and civil society, will be responsible to use that information to put enough pressure on companies to trigger corporate change. But what we see in practice is that this type of regulation have actually failed to trigger meaningful corporate change. And there are huge issues of non-compliance. So if we look, for instance, in relation to UK Modern Slavery Act, it's estimated that around 40% of companies subjected to the Act are actually non-compliant, not complying with their obligations. So what we're seeing sort of more recently is a different type of regulation that seeks to go beyond mere reporting requirements to actually require companies to undertake substantive due diligence. And here we see 2 categories of those. Some of them are specific to a certain issue. That is, for instance, the case of the Dutch Child Labour Due Diligence Act, which is a legislation that was adopted in 2019 but has not yet entered into force. and aimed to require companies selling goods and services onto the Dutch market to exercise due diligence to ensure that child labor is not being used in their supply chains. We're also seeing, and again, this is more the trend more recently, what is maybe more the approach that is more favored recently, legislation and mandatory human rights, and sometimes even environmental due diligence, which are more overarching, so including not just a specific issue, but all internationally recognized human rights, and sometimes environmental standards as well. The pioneer in this respect was the French Due Diligence Act, which was adopted in 2017, and which requires large French companies to put in place and effectively implement a plan de vigilance, so a vigilance plan, setting out the due diligence measures that the company is taking to identify, to prevent, to mitigate adverse human rights and environmental impacts that result from their own activities, but also from the activities of their established business relationship. And then this year, 2 new laws were adopted. The Norwegian Transparency Act, which was adopted in June this year, so very recent, which will require Norwegian companies, but also foreign companies offering goods and services in Norway to undertake human rights due diligence with regards both to human rights, but also to decent work. And also adopted in June, the German Act on corporate due diligence obligations in supply chain, which will require large German companies to exercise due diligence, again, with regards to human rights and with regard to certain environmental related risks which are listed in the legislation. So what we are seeing really is that momentum in support of mandatory human rights and environmental due diligence in Europe. You can see here on that map from ECCJ, really the countries that have already adopted such laws in green, but also in blue, you can see the countries where campaigns are going on, where legislative proposals are being put forward, and in red as well. So you can see there is a real momentum happening in Europe. And there are several proposals that are also pending in various countries, including in the Netherlands. I mentioned the Child Labor Act earlier, but there is also a pending proposal for a more overarching legislation which would cover all internationally recognized human rights. And last in September, there's also a proposal that was put forward before the Parliament in Belgium. So quite a lot of legislative development going on in various countries in Europe. Now, moving to what is going on at the European level. So in our study for the European Commission, we are looking at what already existed in terms of the regulatory landscape. We established 4 regulatory options, including starting from maintaining the status quo, to introducing new voluntary guidelines, new reporting regulations, and new regulation that would require mandatory human rights and environmental due diligence at the EU level, with various sub-options depending on the scope, whether it would apply just to large companies or to SMEs, the type of duty, the type of enforcement mechanism, etc. And an important part of our discussions with various stakeholders across Europe was also to understand what their perceptions were around these regulatory options. And we found that the majority of the stakeholders supported the introduction of mandatory human rights and environmental due diligence at the EU level. This was very much perceived to be the regulatory option that would yield the greatest positive social, environmental, and human rights potential in terms of having positive impacts. But also, and interestingly, nearly 70% of the companies that we surveyed also thought that it would be beneficial for them, beneficial for business. And the reason for that were in particular linked to the fact that it would provide a harmonized EU-level standards rather than fragmented requirements at the national level. I was just showing you all these different laws, which have different building blocks, different scope of applications, different reach down the supply chain, different types of obligations, and that does create a certain legal uncertainty for companies. So companies were, or the majority of the companies we spoke with were in favor of having that harmonized approach at the EU level to provide more legal certainty to avoid that fragmentation, but also to level the playing field. And this was also an important argument, especially put forward by the companies that had already started their human rights journey and wanted the others to be sort of held by the same standards. So where are we at? On the 29th of April last year, 2020, the EU Commissioner for Justice, Didier Reynders, presented our study to the European Parliament's Working Group on Responsible Business Conduct. And based on the findings, he announced the introduction of a proposal, a legislative proposal, on mandatory human rights and environmental due diligence at the EU level this year in 2021. Since then, the European Parliament adopted in March this year a resolution which contains recommendations to the European Commission on corporate due diligence and corporate accountability, and with the text of what could be a draft directive. I'll just make a little parenthesis here for those who might be a bit less familiar with the lawmaking system in Europe. In Europe, the European Commission is the one who has a legislative initiative. So it is the body that can actually propose the law. The ones who vote are then the European Parliament and the Council of the European Union. So the reason why the European Parliament adopted that resolution with a draft text of the directive is really to sort of influence the Commission. And because the report was adopted with such a vast majority, it had 504 votes in favor and only 79 against, it sends a very, very strong signal to the European Commission that should the text of the Commission be aligned with the one of the European Parliament, it will have its support and it will be voted in favor of by the European Parliament. So an important political message there. And what does the text of the European Parliament tell us? Well, basically, the draft text of the European Parliament concerns not only European companies, so large companies, but also certain small and medium enterprises, but also companies that are based outside of the European Union, but that provides goods and sell services onto the European market. So quite a wide scope of application. And these companies, should that text be adopted, or a similar one, will be required to exercise effective due diligence with respect to human rights, the environment, including climate change, and good governance. And this is both in their operations, but also throughout their business relationships. So legal changes are coming. We are now expecting the text of the European Commission in December, so very soon, just in a few weeks' time. And this is what is sort of happening in a nutshell at the sort of legislative level. In parallel to that, I just wanted to make a very brief note of the fact that there are important case law developments that are going on. And I won't go too much in detail because I know my colleague Danielle will also talk about this. But I'll just make a note here to say that this case law development are also contributing to the crystallization of these human rights due diligence and environmental due diligence expectations turning them into sort of legally binding obligations. And so, for instance, in a recent ruling of the Court of Appeal of The Hague against Shell in May this year, the court ordered Shell to reduce its CO2 emissions by 45% by 2030 compared to 2019 levels. And it based that obligation on an unwritten standard of care under Dutch law. But interestingly, the court made express references to international soft law instruments such as the UN Guiding Principles on business and human rights to say that these instruments are relevant to give content to that unwritten standard of care. So in other words, that sort of standard of care that is expected of companies. So we are seeing these sort of examples of case law, which also seek to give teeth to these soft law instruments and the human rights and environmental due diligence expectations by companies in Europe. And with that, I will conclude my presentation, and thank you very much for your attention.
Thank you so much, Professor Claire, for this important overview on business and human rights due diligence and regulatory landscape in Europe. Now, I will hand over the floor to Professor Daniel. Professor Daniel, the floor is yours.
Again, second attempt. First of all, then my apologies for forgetting to unmute myself. Second, apologies for not having a PowerPoint presentation. That was a bit on purpose because I was trusting I could build on Claire and Karin's analysis. Karin, who unfortunately can't be with us, to perhaps invite a debate on some of the broader regulatory context in which this recent European regulatory development takes place. Now, I mean, as expected, Claire said what there was to be said about the various initiatives that are out there, and then I might add some things about remedies towards the end to compensate a little bit perhaps for Karin's absence today. Now, I thought I would like to offer a bit of a more critical reading of this recent regulatory turn on business and human rights, not so much because I have any particular normative conclusion to offer in terms this is great or this is awful or whatever, but because I think the debate has now matured to an extent that beyond talking about the best regulatory approach and so on, we should try to integrate some broader themes. Some of them are indeed old global north, global south themes into this business and human rights debate and home state regulation. In a sense, the term home state regulation, as I often call it, is less neutral than supply chain due diligence legislation, because home state regulation tells you where this is coming from in general, from the so-called home states of these global business enterprises. And of course, what we're seeing here is a development that is very much driven from Europe at the moment. It's not only in Europe, but this is clearly where sort of the focus is at the moment, and where most is happening and has happened over the past years. Now, in a way, of course, what we're seeing here is yet another attempt to bind globally operating business enterprises to human rights standards. And what we're seeing is the so far most successful attempt to bind them to legal standards, right? So again, the attempted shift, perhaps still from corporate social responsibilities that are private, voluntary, not necessarily initially at least geared to human rights standards, to public legislation, because that's what it ultimately is, right? It's domestic legislation at the member state in Europe or at the European level. And in a way that makes sense, giving a long history of complaints, particularly but not exclusively on the part of civil society organizations, that without hard binding standards, we won't get anywhere, because companies will not internalize these standards and then act accordingly, except when it is in their best business interest. And some of what Claire said, of course, that wasn't just a problem of corporate social responsibility. The problem has perpetuated itself with the second pillar of the UN guiding principles that was neither voluntary nor legally binding, but mandatory in the sense of a global standards of expected conduct, the social license to operate. And again, there, when we look at Europe, at least sort of the uptake by companies is fair to say is quite disappointing. It also makes sense, I think, to just turn to hard law. If you look at some of the reactions that you get from certain companies, but in particular business associations in quite a number of countries, a strong resistance, very strong lobbying, in particular in the area of remedies. And I'll say a bit more about this towards the end, why this is so important, the remedies here. So yes, this all makes sense, right? That it comes from Europe because there are many multinationals and because there's a lot of regulatory power, and that it is trying to use law. And more specifically here, law that reaches out into global supply chains, which means from a public perspective, law that applies extraterritorially, right? And here, this all makes sense, but it's also sort of the entry point for various traditions of scholarship that may look much more skeptically at the success of these attempts. One way, and I'll keep this relatively general and pragmatic rather than philosophical or theoretical, but one way to think about this is, of course, that we, and that is countries in the global north, have used law previously for regulating the global economy, including through human rights. Yeah. And this previously is basically the turn to neoliberalism since the 1980s, where human rights were used as a way to crack open markets and as a way to secure foreign investment, yeah, by engineering judicial reforms, rule of law in countries, in host countries of corporate investment in the global south. So this is one of the concerns, right? To what extent do we manage to break with this past and overcome this unholy, I would say, alliance between human rights and neoliberal globalization? The second challenge, a related challenge, again, and this is perhaps more about the unilateral nature of this type of regulation, is a challenge that would come from people who are more concerned, sort of would go back to the new international economic order and would be more concerned about state sovereignty than perhaps along the neo-Marxist line about global supply chains as parts of markets. And here we have a similar problem in a way, because of course, what we're trying to do with this home state regulation is to make sure that companies incorporated or otherwise doing business in Europe respect human rights throughout their global operations. But what we are also doing here is indirectly, at least, regulating third states on the back of global market actors. Because in any realistic market scenario, it's not simply companies, but also states at the receiving end that they will find that they may either need to adopt their regulatory models, or indeed that they may be forced into a certain type of policies that, and this is a classical concern, in one way or the other unfairly sort of unfairly reduces their what's the word here, makes worse, let's say, their competitive position in global markets. Yeah. So here the concern is very much, is Europe doing this because we're trying to ultimately protect our national industries by creating a global standard everyone has to comply with? Yeah. Now all of this is much more complex, and it's especially not as one-sided as I discussed it here, right? All these issues intersect in complex ways. But I think we need to in the European debate, we need to sort of reinsert these old themes. And from my perspective, and this is why I thought I'd bring this up here, I'd be very keen to hear much more about how this looks like from a region where, you know, much of the investment lands and where much of this type of regulation is meant to have an effect. If this perhaps as a general part of my presentation, let me look a bit more specifically at some of the initiatives that that Claire mentioned, and perhaps focus on, let me focus on two aspects, and then if we have time in the discussion, I can elaborate others. But one is, if you're looking at the most recent crisis of global supply chain management, right, the coronavirus, the pandemic, and if you then look at what Europeans are concerned about, it's mainly we don't get enough microchips and we're running out of cars and so on and so on. Yeah. But when you look at it from the perspective, when you look at go down, so to speak, from the top to the bottom of the supply chain, then you will find that across different sectors, once again, I mean, it's the workers at the bottom of the supply chain that suffer most. So if in Europe there's a concern with clothing shops are shut down, consumers can't go out, major retailers run into financial difficulties, then the response is we cancel orders, we renegotiate prices, and the consequence ultimately is that people in the garment factories in Bangladesh, elsewhere, lose their jobs and therewith lose their means of subsistence. Yeah? Or alternatively, because again, a global north problem, we do not manage to produce sufficient vaccination. We do not let others do it. We do not distribute it fairly. Those who are still in work in these garment factories work under health conditions that would be unacceptable anywhere in the countries where the clothes are being bought. Yeah. You could tell a similar story about the food sector where the problems are slightly different. But in all of these cases, what is crucial, that's my point when I look at these initiatives, what is crucial is really the lower tiers of the supply chain. Because that's where the most egregious human rights violations happen. And there you see, of course, that in various ways, many of the regulations we've seen remain insufficient. At the European level, I think this will be a further debate, and we'll see. It's too early to tell where this will be going, but perhaps sort of the most poignant example here is indeed the German law that was adopted this year, where, like to put it simply, we only care about direct suppliers, and if there's something happens further down the supply chain in exceptional circumstances, companies may want to look into this as well. Now, why do you do this? And this is a bit the sort of a correlative point to the one, is it about protecting our national industries or protecting human rights abroad? Of course, I mean, regulators in Europe are concerned about the capacity of these companies, or this is at least the argument that's put forward. Are companies capable of surveying the entire supply chain? Of course, they seem perfectly capable of doing so economically. Then the question is, why would they not be able to do so from a human rights perspective? But you see, I mean, there it's clearly, it's one of the aspects where you could say, well, this is what we have now is better than nothing. But I'm not convinced that it really is. Is it not? One could also say it simply perpetuates an unsustainable business model by sort of fixing it a little bit at the margins. And then the second point, I'm not quite sure how I'm doing on time. The second point is then about remedies, and many people, including Claire, have pointed out the importance of remedies because civil remedies, tort remedies, because this is actually the only type of remediation, if there's any other at all, that sort of affords monetary compensation to victims. Yeah? But in the light of my sort of previous discussion, I would like to add another very important, for me, very important aspect of also civil remedies here, which is, you know, as human rights lawyers, we tend to think that rights and remedies belong together. Now, if European states afford, so to speak, human rights protection to people in other countries by way of a unilateral regulation, then I think the least you would expect in terms of mitigating concerns about market hegemony, new forms of imperialism, is to give those who are supposed to benefit from these rights also an opportunity to claim these rights in our courts, right? I think an important sort of broader aspect of this remediation debate, put differently, is that we also have the voices that come from the countries where the investment goes count against us in our court, if that makes any sense. Give them a legal and political voice in the states where this type of regulation is designed. And maybe a final aspect of this is then, of course, moving from Brussels to Geneva, the discussion. You will familiar with this of a business and human rights treaty, the negotiations that go on. And again, it sheds a certain light also on home states or supply chain due diligence legislation initiatives in Europe, because we see that in the background here is that the European Union has long been very supportive of the UN guiding principles on business and human rights. And then following John Ruggie has taken a quite skeptical attitude, to formulate it politely, towards the treaty negotiations in Geneva. But we've now reached a point where many of the concerns that were raised by the European Union have been reasonably accommodated by the drafters of the treaty. But I think we still see here a certain discrepancy between, on the one hand, so strongly supporting unilateral extraterritorial regulation, and on the other hand, being reasonably reserved or skeptical towards a multilateral international framework that would actually ultimately strengthen and legitimize the type of home state regulation that we currently see in Europe. As I said, to conclude this, I'm not suggesting any particular conclusions should be drawn from this. On the contrary, what I would be suggesting is that we need to look critically, but also in very much empirical detail, at what's happening with this regulatory initiatives in Europe. And certainly, one conclusion I would draw, then a more definite conclusion, is that the more difficult questions that are raised by this are not answered simply in terms of moving from corporate voluntarism to legal regulation and enforcement. Thank you.
Thank you so much, Professor Daniel, for this complementary and critical view on the subject. I just want to make a highlight here. Due to personal circumstances, Professor João Paulo and Professor Karen Bowman were not able to join us today, but I will make some questions that our audience make, and myself also. As you said, Professor Claire, we are in this momentum of the development of business and human rights and environmental due diligence legislations. But as you said, we have a lot of voluntary measures also. So how companies should make this smart mix between soft and hard law instruments? And the second question is, how are the limits of the development of this human rights and environmental due diligence for small and medium enterprises, consider that these enterprises are the majority in Europe and also here in Latin America? The third question, how do you see this human rights and environmental due diligence traveling and reaching, for example, Latin American basis enterprises? Do you think this European framework can be translated into Latin American and other region realities? And assuming normal life cycle, it seems that human rights due diligence rapidly cascading to and has been internalized through criticalization of human rights, environmental due diligence obligations. To which elements do you connect such a rapid pace of human rights due diligence? So I think these questions can be answered by both of you, but feel free to select what you prefer to answer. Okay.
Well, first of all, thank you so much for all these excellent questions. So I'll make a few comments that answer some of those questions. First of all, maybe starting on the question which was touched upon the limitation of these instruments and the mandatory human rights and environmental due diligence for small and medium companies. You're absolutely right, Raphael, to point out that this is a majority. In fact, 99% of the companies in Europe are small and medium enterprises. Here in Portugal, it's even micro enterprises that are at the majority. So that's a very important fact. And when we look at examples of legislations like the ones I mentioned earlier, we see that the majority of them, almost all of them, in fact, apart from the Dutch Child Labour Due Diligence Act, are limited to larger companies. The reason for that is this text, and this is something Danielle alluded to earlier, are the results of a political compromise. In France, when I was talking earlier about the French due-diligence law, this is a law that took 4 years to be adopted. The reason why it took 4 years to be adopted is because there was a lot of resistance from the business lobby. Danielle was mentioning earlier the business associations in France that were very, the MEDEF in particular, were extremely vocal against the law. And so the law, the draft text was sent back and forth between the various chambers of the French Parliament for 4 years. And eventually it was adopted in a watered down version compared to what was the original version. And the original version was meant to apply to all companies and not just large companies. Now, the result, the text that has been adopted, as I said, is a compromise. And the scope is actually quite narrow because it's estimated that the number of companies subjected to the law is about between 230 to 270 companies. We can't have an exact numbers. There are some discussions around the scope and the uncertainties, but that's estimation. So very small number of companies. That in itself, the fact that the majority of these regulations are limited to larger companies is problematic. And in my view, if we look at the UN guiding principles, it's very clear that the human rights obligations apply to all companies, and regardless of the size, but there is a sort of proportionality built into it. So less is expected from a smaller company with less complex and smaller supply chain. But there are also studies that show that it's actually, because one argument we often hear is that the small and medium companies just don't have the financial means to do that. But there are studies that show that it's actually less costly for them to do so, and easier in a way, specifically because they tend to have smaller supply chain, more direct relationship with their suppliers. And another point that I'd like to mention is even this legislation that only apply to larger companies have trickle-down effects on the smaller ones. In France, for instance, there is a study from PwC which shows that 80% of small and medium French companies that supply to the larger companies that are subjected to the law have been required by these companies to put in place human rights due diligence processes. Now, the problem of that is because they haven't been incorporated, they're not subjected to the law. So they're required to do due diligence, not by the law, but by the companies that they supply the goods to, right? And so these larger companies, the study shows that they're not giving them any of these sort of accompanying measures that would help them to do that. So they're asking them to do due diligence, but they're not giving them the financial means, the training, they're not giving them anything to sort of help them fulfill that. And that is problematic. And I think sort of including SMEs in legislation makes sense because it also allows to have specific provisions for them rather than leaving it up to the larger companies to sort of discharge their responsibilities on them. And we see, for instance, in the draft from the European Parliament that it contains several provisions for small and medium enterprises. It requires to give them some specific guidance, financial help, etc. And I think that's actually major. In relation to the question of the smart mix and how a company should approach that, one positive element that I see in this fragmented landscape that I was talking about earlier is that all the legislations refer to the UN Guiding Principles on Business and Human Rights or the OECD guidelines, but the OECD guidelines were revised to align with the UNGP, so we're talking about the same thing. And so there is that, for me, that sort of hope that at least the converging point of all these different legislation that do have different scope, different sort of reach down the supply chains, etc., at least they have that point in common, that converging point, which is a reference to the UN Guiding Principles on Business and Human Rights. So how can companies approach it? I think by following the UN Guiding Principles and the OECD guidelines, which also have a lot of sector-specific guidelines to sort of help in relation to specific sector. I think that's sort of the main message there. I think I will leave the question about the framework where it can be translated to Latin America to Daniel. I'll just finish briefly on the question, which was about the sort of elements, what sort of triggered all this rapid pace of legislations on due diligence. I think there's several elements. Certainly in France, what we saw is that the French due diligence, the idea behind the French law was predated the Rana Plaza disaster, but it was given a decisive push afterwards. Why? Because when the Rana Plaza building collapsed in Bangladesh, causing thousands of people to die, and this was, that collapse was linked to poor health and safety issues, right? What happened in France is there was a massive public outcry because there were articles in the news that showed that these factories in that building, in the Rana Plaza, were the ones supplying the clothes to French as well as other European brands like Carrefour, etc. And so people started to connect the dots and say, okay, so I'm buying my things from this company here, but they're getting their things from there, and here the health and safety standards are horrible, a lot of people died, etc. And I think that sort of, so first of all, that sort of public pressure has played a role. I would say consumers are more asking for sustainable standards now in Europe. And in fact, when we look at the Dutch Child Labour Due Diligence Act, interestingly, it's framed in terms of consumer protection. So the idea is to give Dutch consumer peace of mind, and that's what the legislation says, but they can buy their products and that they haven't been the result of child labor. So I think that's also another aspect. And the pressure from investors also, I think, is very strong. And I will stop here to give the floor to Daniel.
Yes, leaving me with a difficult question. No, I find it's the translatability of the framework. Can I just ask, by framework, do you mean the UN Guiding Principles on Business and Human Rights, or the supply chain due diligence legislation? What framework are you referring to?
I think the question is about the human rights due diligence legislation, I guess.
Yeah, I mean, I'm asking this because to me, this type of supply chain due diligence legislation is but one of many ways in which you could contribute to the implementation of the UN Guiding Principles, including through law, right? There may be other legal avenues. Now, I find it a bit difficult to sort of gauge sort of the situation in I know some parts of Latin America better than others, Colombia, Mexico to some extent. I find it difficult to comment on Brazil. But what I can say, a few things I can say, more general things. One is, of course, the supply chain due diligence legislation in crucial parts follows the money, right? So there is still at least this crude idea that, I mean, this is something that moves from capital exporting to capital importing states. And in some ways, again, this idea is misleading because it seems to suggest that we wouldn't have human rights violations in supply chains in the European Union, whereas in effect, we have tons of them, right? So I don't think one should do numbers in human rights debates, first of all, right? It's not so much about how many victims, but that they are victims in the first place. But we have significant structural issues with especially labor exploitation, especially when it comes to migrant workers in many parts of the European Union. So one needs to be careful here not to sort of fall into too simplistic message of, because some of the message is about two things, right? The supply chain due diligence legislation. It is about helping other countries to live up to their human rights commitments. And it's about helping our own consumers and investors to make ethical choices. So our own here being, again, the European. Yeah. And the latter argument is partly, I guess, an expression of political compromise, because you do take in this market interests into account. It's partly related to jurisdictional concerns that you need to look back home to justify that you're trying to regulate abroad, to put it very simply. So the question, I mean, in some sense, the question may, and this was part of my more critical remark, the question whether how it can be translated in Brazil may not pose itself as such, because if this is successful, it will already be in Brazil. Right? Because this is European states indirectly regulating Brazil on the back of global market actors through the supply chain. So it's a mistake to buy into a too easy distinction between public and private here. So there are indirect regulatory effect on Brazil's, the more this becomes, and whether you think that's a good thing or bad thing depends very much perhaps on the context. I think more generally also, the more countries adopt this type of regulation, the more complex, the more pluralistic the international regulatory framework will become. Because so far, most countries have gone for their own standards, their own concerns, et cetera, which is partly, I guess, why you see this movement towards consolidation in the European Union, where you have at least one standard. I don't know enough about sort of the Brazilian situation in international investment to tell you whether and I don't know whether there is a supply chain due diligence law being discussed in Brazil. So that's a bit hard for me to say anything more, except that my perception from the other debate, the treaty debate, is that sort of tendentially speaking, there's a tendency from the global north about better regulation, and a tendency from the global south that more strongly emphasize the question of remedies. So the question to what extent states in the global north should open up their court systems to claims by countries in the global south. Please get back to me if that wasn't enough of an answer, but you see that at some point I'm becoming a bit careful to talk about things that are genuinely sort of should be answered by someone from Brazil, actually.
Thank you so much. It was great, Professor. Pop up in the chat 2 other questions. We will do this final round. The first one, the human rights due diligence process seems to be clearly evolved and succeeding in identifying and preventing human rights risks. But there is still a lot to be done when we talk about the accountability of private actors. What are the means we can work on to have a better accountability mechanisms in business? And the second one, Considering that Brazil, we are still in an initial stage of this conversation, especially in legislative and regulatory sphere, do you consider that the companies should be part of the policy design and agenda setting? And how? Should they be proactive and engaged with legislature and all the other policymakers? Should governments include the firms in the decision-making and designing of the laws, regulations, and how? So I think the people, the person want to know if you have some European experience to share with us. So the floor is yours now. I don't know who wants to answer.
I don't know if Danielle, you want to go first this time, so then I'll go second.
So, I mean, the only, I don't want to be always the dystopian person here, but sort of the debate I've been most closely involved in was the German debate, where you had a very, this is talking about the role of companies, or perhaps more generally business associations and business representatives. So in the German debate, you had a very extensive, reasonably extensive stakeholder consultation involving all sorts of different groups, speaking to concerns, and then you had some sort of early unofficial draft. And almost up to the finishing line, it looked like that we would get a relatively robust and solid law, including remedies. And then basically when everything was said and done, one of the ministries heavily lobbied by business associations interfered and significantly watered down the text of the initiative to an extent that we have it now. So if you're talking about sort of the involvement of at least parts, I should also say that there have been in the German debate, some of the largest enterprises have been very supportive of the law. Whether they would have supported the remedy bit is a bit of a different question, but they would have supported a stronger law than we have it now. So my personal experience with the engagement of certain types of the business world in negotiating these legislations is not great. The other thing I would like to say, and then I pass on to Claire, who knows more about these things, is that it should be clear that we can't do this without the companies. So sometimes you also get this perception that once you have enforceable legal standards, then the problem is solved. But unless you have a significant part of companies being willing to comply voluntarily, with the law, so without, then you will not address what Draghi called sort of the business and human rights predicament in its entirety. And that's, it's not simply because we're talking here about complex supply chains and so on. It's quite simply always the fact that unless the majority of people are sort of voluntarily go along with what the law requires for whatever reasons, then the law will not work, because no state or no other entity has the enforcement capacities. And, and we don't want to live in dictatorships, most of us at least. And so we need to bring these companies in, and we need to involve them in these legislative debates, at the same time making sure that they don't jeopardize the results that we would like to see in terms of regulating companies' human rights impacts.
Yes, I think I completely agree with what Daniel was saying. We've seen, interestingly, in the study of the European Commission, we've seen a sort of almost disjunct between the discourse of the business associations and individual companies. Often we found individual companies being a lot more supportive of legislation on mandatory due diligence than business associations that were by far the most reluctant of all this type of stakeholders that we spoke with. And so sometimes there is that sort of, discrepancy there. But it's helpful to have and it's really important to have companies on board, but their perception can also evolve. So if we look at the French video vigilance law that I was talking about, originally French companies, a lot of them were extremely hostile to the law. And now with the discussions of what is going on at the European level, often we see these companies, these French companies that were resisting the French law, they're the ones that are being very vocal in favor of the European legislation. Now, there's a very obvious reason behind it. Of course, now that they're subjected to the law, they want to level the playing field, obviously. But it's interesting to see these changes, with how this has evolved. So there is hope for evolution, I would say. Now, on the other question that was posed before about accountability and how we can improve the accountability mechanism, etc. Here I would say, and that's not just in relation to the accountability part, but generally on the whole of the human rights due diligence process. When we look at the experience, in particular, I often refer to the French law because, well, first of all, I'm French. I've been following very closely the developments, but also because that is the law, the example that we have with most, that has been in place for a few years. So we have a bit now of distance, and we can sort of see what is the implications and the impact that it's had. And so last year there was a report that was made for the French government on the implementation of the French law. And one of the main pitfalls and one of the main criticism in this sort of implementation of the due diligence by a French company was a lack of stakeholder engagement. And I think this is interesting, that stakeholder engagement is something that is encouraged in the French law, but it's not made compulsory. It's made only compulsory in relation to one specific, which is setting out the whistleblowing mechanism, but just in relation to that specific aspect. For the rest, it's encouraged on. And so this is one of the main pitfalls. And I think that's particularly problematic. And if we go back to the UN guiding principle, stakeholder engagement is central to the entirety of the human rights due diligence process, from identifying what your impacts are, to putting in place an action plan to address them, to setting out your remediation mechanism. And you cannot have a human rights due diligence process that is effective and appropriate if you don't have meaningful engagement with potentially affected stakeholders. I'm thinking workers, employees, I'm thinking local communities, trade unions, NGOs, etc. And that's something that we often see lacking. In relation to the sort of accountability mechanism, the sort of grievance mechanism, that's absolutely key. Now, I'm very cautious when talking about grievance mechanism. I think they can be helpful, but you cannot and should not privatize justice. So I think they can be helpful only to the extent that they do not prevent people to actually go before the judge and seek justice before the judge. And I think that's really, really important to emphasize that. So I think that's the points I wanted to make there.
So with that, I thank you, Professor Claire Bright and Professor Daniel, for being with us today, having this conversation. I hope next time in person here in Brazil. I also thank the audience that is with us today. Don't forget to follow our activities on YouTube and Zoom. Tonight we'll have a panel on the role of academia and civil society in the defense of democracy and human rights. So thank you so much, and bye-bye.
And thank you for the invitation.
Bye-bye. Bye-bye.
Bye.